Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about what I consider to be a really significant and important alternative to bankruptcy, and that is debt negotiation. What I have found is that bankruptcy, especially after the changes in the law back in 2005, has become less adaptable, and that means that more and more times I'm seeing clients who just don't easily fit into the traditional Chapter 7 or Chapter 13 types of bankruptcy. Frequently, the household income is too high to qualify the person for Chapter 7, and Chapter 13 just doesn't really work really well. Chapter 13 may not work because the person's self-employed. Those cases don't work really well. It could be a problem because my client may have a job where payroll deduction, which is the way Chapter 13s are funded in the Northern District of Georgia, would not really be feasible. It may be a problem because pay is not consistent. It could be a problem just because the person has more than maybe 2 or 3 rental properties, and Chapter 13 doesn't really work very well with that. So there could be a lot of reasons. I think Chapter 13 it can be a very useful tool, but it's also a pain in the rear end because for the next 5 years you've got a Chapter 13 trustee to deal with. Anything you want to do, whether it's buying or selling property or a car, you've got to get permission. And in many cases, I think especially cases where income is not consistent, it can be very hard to make a Chapter 13 work. And there's also situations where people are in the middle of negotiating some tax debt, or they're negotiating a mortgage modification. You file Chapter 13, that puts a stop to all that stuff. So a lot of reasons why 13 won't work, a lot of reasons why 7 won't work. But negotiation can be a pretty good option. And what I find, people do retain me for negotiations. What I find I really need is kind of the same information I would need for a bankruptcy. What we try to show is that the likelihood that this particular creditor that I'm trying to negotiate with, that this person's going to get paid is really relatively small, because my client has so many other debts to deal with. If there's tax debts, that's usually a pretty good argument. If the person is self-employed, trying to collect it becomes an argument that you can use. And a lot of times it involves really a lot of just grunt work of going through and trying to get to a person who can make a decision. And that's really a big part of it. Frequently, you have to be behind. A lot of times the creditors will not talk to you until you're 3 or 4 months behind, and that can be kind of difficult because you don't want to get the phone calls, but you really have to be behind before they will talk to you. So those are some of the things. I find that I can sometimes be useful in the sense that I'm not emotionally involved and you're not talking about my debt, whereas when you're talking to a creditor yourself, they start trying to pressure you and bully you into giving them access to your checking account, or sending a payment by wire, Western Union, that type of thing. I find I can sort of puts a little distance between that, and a lot of times that will be a way for me to negotiate maybe a little better settlement because there's no emotional involvement. The other thing that I've been doing more and more is I look at some of these cases to see, is there any kind of leverage I have because of some violation of the FDCPA, Fair Debt Collection Practices Act? Is there some sort of a truth in lending problem, something wrong with the application? There could be any number of reasons, but I've seen situations where banks will help fill out somebody's application and they'll misrepresent the person's income. And it was not the person's handwriting. He didn't do it, but somebody at the bank did. And that sometimes is leverage that you can use to try to argue that the bank has got some liability there, and use that to try to negotiate. So when I look at a debt negotiation, I try to look at every facet of it, from the application through payment history, through collection efforts by the creditor, to see if there's any leverage I've got to try to argue that they're either not going to get paid, or that they may owe my client money for something they've done wrong. A lot of times collectors can get really, really aggressive, and sometimes you can find that they've done some things wrong, and it's really helped us in some situations settle cases for some significant discounts. And finally, when we do settle it, sometimes I'm able to negotiate a deal where it will not be reported negatively on the credit report, or the negative references can be taken off. Doesn't always work that way, but it's always good to ask for that. So ideally, my client comes out owing less money, not having filed bankruptcy, with a credit report that has been restored, or certainly not as blemished as it otherwise would have been. So that's really the way I approach debt negotiation. I always encourage people, if bankruptcy is an option, certainly to consider it, to look into the bankruptcy option, see what it looks like. But if you can avoid bankruptcy, by all means avoid it. It's not a good thing to do. It's not a perfect remedy, and in many cases it can obviously mess up your credit, and it has some long-term repercussions that are not very helpful. If you can get away with a debt negotiation, oftentimes a better solution. So I hope this has been helpful. This has been Jonathan Ginsberg talking about my favorite alternative to bankruptcy, which is a debt negotiation. Got any questions? Give me a holler. We'll talk to you soon. Bye-bye.